Section 13. All persons except those charged with offenses punishable by the reclusion perpetua when evidence of guilt is strong shall before conviction be reliable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. So in this section, it states that an accused who's charged with an offense punishable for reclusion perpetua, the writ of habeas corpus is suspended and bail is discreted. So next is the section 14. No person shall be held to answer for criminal offense without due process of law. So in a criminal prosecution, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witness face to face, and to have compulsory process to secure the attendance of the witness, and the production of evidence in his behalf. However, after the arraignment, trial may proceed notwithstanding the absence of the accused, provided that he was been duly notified of his failure to appear in unjustifiable. So in this section, it stated that the presumption of innocence of the cause until contrary is provided by the evidence beyond reasonable doubt. So in section 15, the privilege on the writ of habeas corpus shall not be suspended except in the case of invasion of rebellion with the public safety requires it. So in this section, it states that the case of invasion or rebellion when the public safety requires is may be suspended, the privilege of writ of habeas corpus is denied. So next is section 16. All persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. So in this section states that these rights aim to protect the person from intentionally long run drawn out of detention and imprisonment. Next is section 17, that no person shall be compelled to be a witness against himself. So in this section states that person cannot be compelled to testify or produce evidence in criminal case on his own. Section 18, no person shall be detained solely by reason on his political beliefs and aspiration. No involuntary servitude and any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. So in this section, it states that no one may be held prisoner purely because of his her political ideals and views. So in section 19, excessive fine shall not be imposed nor cruel degrading of inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provide for it. Any death penalty already imposed shall be reduced to reclusion perpetua. The employment of physical, psychological, and degrading punishment against any prisoner, detainee, or the use of standard of inadequate penal facilities under subhuman conditions shall be dealt with by the law. So, in this section, any death penalty already imposed shall be reduced to reclusion perpetua. Next is section 20. No person shall be imprisoned for debt of non-payment or for poll tax. So, in this section, no one can be compelled to pay a debt under pain of criminal sanctions. So, you cannot be imprisoned just because you have debt. Next is Section 21. No person shall be twice put in jeopardy of punishment for the same offense if the act is punished by a law and ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. So in this section, a person cannot be charged with the same or identical crime when such person was already previously convicted and acquitted in the similar crime. So, Section 22, no ex post facto law of bill of attainder shall be enacted, which means one which alters the legal rules of evidence and receive the less testimony than the law required at the time of the commission of the offense. So, in order to convict the accused. And that's it for the 22 sections of the Article 3 of Bill of Rights of the 1987 Philippine Constitution.